A will and trust should be reviewed and updated generally every 3 to 5 years. And that is kind of just a basis to go off of. Sometimes it really depends on the family situation. It also depends on what your age is. Have you gone through any serious health conditions? Is there something that's coming up? So, a lot of these contribute to needing to review those plans. Again, it all depends on what's going on in your life. So, when considering updating your will and trust, and especially when you go to review it, it's important that if you have a specific life event, you don't wait for that time period to happen, right? You make those changes immediately. Some of those life events that may occur would be if you had a child. We want to make sure that the child's information is updated properly and that you have the guardians nominated of who you would want to be listed there. Another life event would be as if you got married. Here, your life is probably in a completely different situation from when you originally created your plan. And you want to make sure that whatever your plan is going to be going forward, that it takes into account your new spouse and what your plans are with your assets, as well as any um, agent nominations that we need to do for that new spouse, as well as any beneficiary designations and inheritances to them. What if somebody that you had listed as an agent in your plan were to pass away? This is the time that you then need to make sure that your estate plan is updated. Depending on how many agents you have listed, it's important that you are able to have backups listed in there. And so for some plans that I've seen, they may not have backups listed. And so when they have somebody that's passed away and there's nobody as a backup, it's important that you get that updated. I will also say that sometimes life events just happen where maybe the people that you identified in your plan years ago, you're no longer friends with. Maybe they've moved away. You need to make sure that your plan is updated so that it was able to follow what you want now, because life is always going to be changing and your estate plan should change with it. So, when it comes to reviewing your estate planning documents, it's not just about looking at one document. So, let's just say you have a will. Let's say you also have a trust. It's not just about reviewing one of those documents, it's about reviewing all of your documents as one. When we look at estate planning, we like to think of an estate plan as a comprehensive plan. This includes a trust, a will, advanced healthcare directive, power of attorney, and many other documents. And so when we sit down with clients to review those plans, it's important that we look at all of them together because a lot of times they do interact with each other and they will have a lot of the same agents listed. So it's important that they are all updated at the same time. So, when updating your estate planning documents, there are certain legal requirements that need to be met. A valid will or a valid trust are important because without them being valid, they essentially don't exist. So, it's important that you follow state rules when it comes to making sure that that will or that trust is enforceable. The same thing with a power of attorney and advanced healthcare directive. Each document is going to have specific things that need to be accomplished to make sure that that document is valid. And that's where working with an estate planning attorney is crucial to make sure that they are a valid document. I had one client. His dad had passed away and he had been on him for so many years to get his trust done. And dad called him one day and said, I finally got my trust done. Many years later, dad passed away. Client comes to me and says, my dad had his trust done. We should be able to avoid probate court. And when I take a look at it, I get to the last page and I realize that dad had never actually signed his trust. So what does this mean? It means that it wasn't valid. So we had to take his very large estate through probate court. And this is something that the son had urged and urged his father to do. And he thought he did it. And unfortunately, because it was not signed properly, it was an invalid document. When you are updating your estate planning documents, it's important that you understand what actually needs to be done to make sure that your updates are valid. I will tell you one thing that is not necessarily going to be valid and may have issues in court is if you take your document and you just start crossing things out and you start writing stuff in there. Even if you initial it and you date it, what can happen, and I've seen this in cases that we've had through probate court, is we never know the intent of why somebody did that. We never know if that they were being coerced into doing it. We never know what the intentions are. Was it just a draft? Was it their ideas? Or was it actually a valid change? So it's important to work with an estate planning attorney to make sure that whatever your changes are, you're able to actually put those in writing so that they are very clear, so that your intention is known. And that's going to cause your family or the situation with whatever's going through court to be a lot easier to go through. So, when you have assets that have beneficiary designations, these are things that the assets don't necessarily have to go through probate court or they're not owned jointly. They have a beneficiary designation. It's important that you are reviewing these beneficiary designations at least annually. And the reason for it is you never know who you had on there. And this can be something that was done when you maybe first created the account, and it was 10, 20 years ago. And so by reviewing those beneficiary designations annually, you at least know what your intention is with those documents, that it is actually valid. So it's important with all of your assets to make sure that you are checking that beneficiary designation. Some of the consequences for failing to update your estate planning documents can be detrimental to your family. One, when you have an estate plan that includes a trust, if you were to get sick, and let's say you never updated your agent, maybe you had a spouse that had passed away, the agent that you have identified in there, the court would actually have to step in to be able to identify who that new agent is going to be. And for somebody that's created a plan, they have this sense that their decisions are already in writing, that their decisions are made. And now it's being brought into court where court actually would have to rule to see who would be in that role. Another consequence is maybe you have somebody in your family that has passed away and you never updated the beneficiary designation in your trust or in your will. And so the intention is well, what would happen to their part of the inheritance that they would be receiving if something were to happen to you? And in some of the cases that I've seen, it's not who they would want to actually receive it. Maybe it's a family member of the child that's now deceased that they have no relationship with. They haven't spoken to them in 20 years. And I do see this happen. That's why it's so important by updating your documents and by having a good understanding as to what's in them, then you can make an educated decision and put what your wishes legally are in writing. So, an example of ensuring that your estate plan is updated, I had a client that had come in with his mother, and her husband had passed away, and she really just didn't know what was in her estate plan at that point. So, I did a review for her and went over it where we could discuss the provisions that she had in her trust. And as I was going through them, she found one of the provisions where I had said that her son that had died prior to us having this conversation, that all of his portion would go to his son. And the problem that she had with this is that the son hadn't been in any relationship with that child in her entire life. They had never had a relationship. She didn't even know who this boy was. And so she had a lot of issues with half of her estate going to this child that she did not know. And so by having that conversation and by looking at what the terms of her trust was, she was able to identify how she didn't want that to happen and then able to make updates to what she actually did want to happen at that point. If you are looking at updating your will or your trust or any of the documents in your estate plan, please consider us at Hermance Law to help you get those documents updated to make sure that everything is legally in writing with what you want now to make sure that your wishes are known.